My lord, I would like to mention item number 7.
7.
Yes.
Yes.
This, I have not filed the affidavit, so this matter will be taken up after 3 weeks.
Sajita.
Yes.
Okay. You have taken. You have,
Yes.
yes. On the prayer of Mr. Tiga, the learned standing counsel Sajita, SJAT. Further, 3 weeks' time is granted to file affidavit of list the matter after 3 weeks.
May I please? Your Lordship, I'm very sorry to mention one item number 22, Your Lordship. So the consent on Bukit General. Okay. Finally, this matter will be listed on 22nd. Your
22nd. There will be on 22nd.
22nd of
September. It's a Tuesday. So
on the prayer of Mr.
Ibam.
Learned counsel appearing on behalf of Arsekya.
Yes,
Your name is not there.
not there.
Learned senior counsel for the petitioners and the prayer not being and as agreed to learned counsel learned advocate general Mr. I. Chaudhry. Let this matter be listed on
22nd.
22nd 09
Yes, sir.
09
Yes, sir.
2020. Yes.
Deeply.
These also rules. Challenging the rules.
May it please your lordship, I beg to mention item number 20.
20.
The council is out of station due to health issue. Lordship.
It's not complete also.
Lordship, may the matter kindly be fixed for 22nd September.
You are?
A Jongluju.
It is submitted by MS
A Jongluju.
A. Chongluju.
A Jongluju.
Learned counsel appearing on behalf of Mr. K. Saxena,
Yes, lordship.
who is for learned counsel for the respondent on the ground that the Mr. Saxena is indisposed today. Let this matter be listed after 3 weeks.
22 September.
22. MS and Anju learned legal counsel is present. Or the appellant is present.
Your Lordship, I beg to mention item number 21. I'm for the appellant here.
On the prayer of Mr.
M. Kambo.
M. Kambo, learned counsel appearing on behalf of Mr.
Arsenal.
Arsenal, learned counsel for the appellant. Let this matter be listed after 3 weeks.
Okay.
This one, husband and wife. Husband and wife.
Bless.
Yes.
Item number 1 and 2.
Lordship, standing counsel is out of station for some. We'll see.
You argue the matter, you are appearing on his behalf.
Lordship, since this pertains to the department.
I think prima facie the judgment of learned single is wrong.
correct, my lord, because
It's wrong.
correct.
Is not it?
Yes. There is a
So
latest
in that
judgment.
case, will the will
My lord, only thing
what is the rule?
only thing to be taken care in this case.
What is the rule?
The rule, my lord, is it is in the petition in the impugn order itself, my lord, has produced the rule, my lord.
Not produced.
Extracted.
You have
extracted.
not. You have not annexed or what?
No, my lord, it is there. Kindly come to page 32 of the impugn judgment, my lord.
Not impugn judgment. We want to see the
It is reproduced.
rule.
Yes,
It's
my lord.
not been annexed. No reproduction we've seen, but what is the rule? Original rule.
Original rule.
It's in page number 64. An extra
64.
62, Your Honor. Oh, 64, Your Honor. An extra.
मेरा वाला में भी होगा लेकिन पेज अलग होगा।
What is for direct recruit? Direct recruit, yes.
10 rule 10 schedule 10 50% by promotion
50%.
and 50% by this thing direct recruit.
I think something wrong. No, it's other way around. Other way around.
Which column, my lord? 10
11.
11. In case of direct promotion, the promotion from amongst the primary teacher department who have completed 5 years of regular service in the grade and possess education qualification prescribed column 7. Column 7, my lord, there are two things. That's why conjunctive and disjunctive has not properly been appreciated. Because the word or and and, my lord will recall that joint director Mine's case. The concept is very clear. The word or is conjunctive, and whenever the word occur n would be disjunctive.
Therefore,
So
it goes
disjunct-
against you.
No. That means one must have the update qualification. And the Supreme Court in the latest judgment interpreting this RT Act to section 23 has clearly held that one must possess update or seated. And teachers retiring before the 5 years who have served for the longer period of 30 years, they are exempted. That is a judgment.
No, we'll go by the rules.
Yes.
It's an interpretation of rule only. So according to you,
7, my lord, will see. 7, my lord, will see. First is graduation and 2 years diploma in elementary education. By whatever name known from a recognized university or institution. Again, the word or graduation at least with 50% marks and 1 year bachelor education, be it from a recognized university.
no, that is
Or
A
graduation.
and B are the relevant.
B,
Or is not important. N is,
and is important for me. And kindly see, and says pass teacher eligibility test or Arunachal Pradesh teacher eligibility test update conducted by central government or the state government. So these are two different, the mandatory provisions after the word end is that one must have a requisite update and seated this thing.
the petitioner is not having this.
No, they are not having, my lord.
So according to you, it is to be read
Conjunctively, my lord.
not disjunctive.
So therefore,
But it says, Rule 7 says education qualification, education and other qualification.
well, it is kindly see.
Column 7 you read,
I'm reading column 7 only.
I mean serial number 7.
Serial number 7B, my lord, will come.
You see,
It starts with the word.
education and other qualification required for the direct recruits, right?
Correct?
It has to be read in conjunctive.
Disjunctive.
Huh?
Disjunctive, because and is coached in negative language, my lord. And is coached in a negative and mandatory.
How?
Because whenever there is a word or,
First tell us whether this is to be read disjunctive or conjunctive.
it has to be read conjunctively because mandatory is and. A person who does not have the update or the TET cannot be given promotion. That is what the law says.
So therefore, it has to be read conjunctive.
Yes.
So you are having this.
I'm having both, Lord. I have qualified. And
Then come to rule, serial number 11.
11 years. In case of recruitment by promotion, from deputation, absorption, grade from so and so absorption, my lord. It says promotion from amongst the primary teacher class 1 to 5 of the department who have completed 5 years. I have completed 5 years, my lord. Regular service in the grade and possessing education qualification prescribed on column 7. Column 7 is one is conjunctive and must have update.
But education qualification, is it include the update and this
Yes,
thing?
it says prescribed on column 7.
Education qualification.
Yes. Huh. And in terms of this 2025 judgment, after interpreting series of things, the apex court has held that the TET and update is also an education qualification. It is mandatory in terms of section.
In the facts of that case.
Same. Because there was a large scale litigation across the country, especially this arises from.
But that rule, that judgment has not considered this rule.
No, judgment has not.
Rule is rule.
But no,
Go by the
rule is there, but then my lord will have the equitable jurisdiction as well.
Okay, what can we do? If
Well,
you allow the writ petition, they will say that they have not
Yes.
been heard. What is the status now?
Status? My lord, there is a stay order. We are still functioning.
Continuing.
Yes, continue in the single bench. Reversion was a state.
State.
Yes. Because here we were not given even opportunity also.
Who is for the respondent?
And
Private respondent. Yes.
Mr. Thafo is also not there today.
What do we say? We can dispose of the matter.
Next date. Next date may be given. Next date may be given.
On the heard Mr. Titithara London Senior Counsel assisted by Mr. G. Bam and Mr. MS Enanju
And Anju.
London Counsel. Respondents, appellants. As prayed for by admit list for hearing after 3 weeks. 3 weeks
Fine.
could have disposed of.
Item number 3.
They have not filed affidavit status.
Uh,
Why? We have given enough time.
my lord, actually,
What is the problem in filing a status?
yes, my lord, of course, my lord. My lord,
What's the problem?
my lord, actually, there was some communication gap between this one, myself and my lord, authority concerned. So that's why, my lord, if we'll file it tomorrow, my lord.
Tomorrow.
Yes, my lord. Or by Monday, my lord. By Monday, my lord.
Heard Mr. Ken, MS Ken Malik, learned counsel for the petitioner. Although this court had observed on the last date of listing that no further opportunity, observed that the last opportunity is provided to bring on record the status, Mr. El Kurdu, learned counsel for the standing cause I am
Yes, my lord.
submits that due to communication gap, status could not be filed. And he undertakes that same would be filed by tomorrow,
By Monday, my lord.
by Monday.
My lord.
Mr. Therefore, praise for listing of the matter after a week. After a week. Considering above, let this matter be listed after 1 week. So as to, in the meantime, the council put the respondents to file the status. He shall invariably file the status.
Authorised.
Obliged. Item number 4.
Non appears for the petitioner on call will dismiss. What is going?
Reply.
That's where. Enough time is given. Enough time. One, two, three, four, five, six. Six times. Non appears for the petitioners on call. Several opportunities. No, neither affidavit in reply as sought for by the petitioners has not been filed despite granting 6 consecutive times for filing the affidavit in reply.
Lordship, the council put a petitioner inform me that he is not coming.
Let him, Mr. Arkoyu, learned counsel, appearing on behalf Titagum, learned counsel of Health and Family Welfare Department, as well as Mr. S. Tapin, learned senior government advocate for the state response are present. Considering that despite repeated opportunities while affidavit in reply by the petitioner and not being represented today, where of the view that the petitioner is no longer interested to pursue this state petition, accordingly it stands dismissed for non-prosecution.
Item number 5.
This is also challenge to the rule. What do you say? Should we give opportunity again? Okay, let them come back for restoration. You know that. Yes.
May I pray for adjournment of this matter, Your Lordship?
Why?
Your Lordship, due to some personal difficulty.
Also not there. As prayed for by parties, let this matter be listed after 4 weeks. 6 also.
6 also. Your Lordship.
Same. You record the end. Arkoyu, appearing on behalf of Mr. T. Tagum, Land Standing Council for the appellant.
E-Menjo.
E-Menjo for respondent.
Hello.
Item number 8.
Adjournments.
Yes.
Yeah, Your Lordship.
Hmm.
Your Lordship, this is an appeal against the conviction order dated 13/11/2025 and the subsequent sentence order dated 17/11/2025, whereby the appellant before this honorable court has been convicted for
We'll admit. We'll admit.
Any notice may be issued to the respondent and 2 also. Okay. And now, my
Okay. Heard MS
R. Taku, Your Lordship.
R. Taku, Land Counsel for the appellant. decision appeal under section 4152 of BNSS 2023. Issuing the judgment dated 13/11/2025 and conviction
Sentence
Sentence.
17/12/2025 passed by the learned district and session judge UP in sessions case number 64 of 2018, whereby the appellant has been convicted and sentenced to undergo life imprisonment. Under section 302
Yes, Your Lordship.
IPC and 2 years under section 201 IPC with a fine of rupees 10,000 with default stipulation. Admit, call for the trial court record.
Yes, madam.
Mr. T. At learned addition PP enters appearance on behalf of the state petitioners to take steps for service of notice upon respondent number 2
Yes, my lord.
in terms of as per notification 17. No,
No, my lord. Usual course.
this is for okay.
Usual course.
Usual process.
That will be after 3 weeks, madam. Or
This is the matter up to 3 weeks.
yes. Deeply obliged, my lord.
Item number 9.
Lordship decision appeal in under section 415 of BNSS against the judgment and order dated 10/2026 passed by
Where
the
is the
land.
sentence order?
Yes, Lordship.
Order of sentence.
Yes, Lordship. 17/2026
Where it is?
passed by the session Judge UPA Lordship.
Where it is?
Annexure 16 to 54 Lordship and sentence 55 to 58 page number
55 to
58. Particularly in page number Lordship 57.
sentence.
Page number Nomit Chomal. This
Huh?
appellant Lordship.
Sentence.
Yes, Lordship. For this present appellant Lordship 57.
Is it so? This is a warrant of commitment. Where's the order of sentence?
Sentence page number Lordship 16 Lordship.
16? 16?
Judgment and order dated 16 to 20 to 55 Lordship to 54.
Huh?
54 Lordship.
If 54 is something different. Where is the order of sentence? There is no order of sentence.
Warrant of commitment.
Page 52.
57.
Page 52. Planning Council, come to page 52.
52.
Yes, 94. Point. Para 94. Read it.
Okay. I have heard the convict and learned counsel appearing for the convict on quantum of sentence. It is prayed that another date may be fixed for order on sentence.
Where is that? Where is that?
Let me allow to correct the same and accordingly I will file additional affidavit. First can limitation. Let me allow to file additional affidavit in regards to sentence, Lord.
Since the appellant has not, since the criminal appeal is not accompanied by the order of sentence, Mr. Pukhon,
G. Pukon.
G. Pukhon, learned counsel for reference for time to press for adjournment of the matter for 2 weeks, 1 week,
2 weeks, 2 weeks.
2 weeks. So as to enable him to bring on record the order of sentence. Whereas allowed this matter after.
Item number 10.
The last occasion, my lord, the Union of India has been directed to file affidavit, my lord, bringing the records of the denial of the prosecution sanction, my lord. My lord, we are under process, my lord. Within 2 weeks, we'll file, my lord, affidavit. So some. Otherwise, my lord, this is the intimation which has been sent by the ministry, my lord, the prosecution.
Mr. Esmo, learned counsel for the petitioner. As spread forth by Mr. M. Kato, learned counsel for the learned DAJ.
For Union of
Last opportunities granted to file affidavit, bring on record, to file affidavit as directed at Mr.
Malad.
Earlier. List after 2 weeks.
Malad.
All right.
Item number 11.
Lordship, I have received a copy filed by the RWD, Lord. Yes, today. I have this series. Can this matter be fixed on the next week?
Which respond number 3 and 4?
Yes, 3 and 4 file affidavit.
Okay. Others, you are not filing.
Others, my lord, since the parental department, my lord, RW, they have filed, my lord. But before that, my lord, your lordship seen, my lord, this PL, my lord. My lord, what they are asking for, my lord, they are asking that the compensation should be made under the PMGS scheme, my lord. And your lordship is aware, my lord, there is no such provision, my lord. So perhaps, my lord, the petitioner, my lord, is a wrong adventure or fallacy to understand the scheme, my lord, that there is no any such provision for land compensation, my lord. The state is the duty of the state government to, my lord, provide free of all, my lord, income branches, my lord. Then only, my lord, the central government will fund it, my lord. So it is the duty of the state government to give free of land, my lord, with the consent of the village. If they want road, my lord, they have to give free of cost, my lord. Basically, this is the concept of the PMGSY, my lord. And they're asking compensation for that, my lord, without challenging the scheme itself. That is the problem.
But last occasion we have recorded there in the guideline there is something. As in the terms of the guideline, there is provision fund for land acquisition. However, the obligation has been cast upon the state government user for management at own cost that may be in the form of land acquisition, voluntary donation, exchange or other mechanism to ensure land availability at the time of placing scheme. That is basically they are saying.
Yes, my lord. Now it is the duty of the state government to give, my lord, free of cost, my lord. My lord. Then only, my lord, we can prepare the DPR and send it to the central government for approval. With the consent of the villagers, my lord, that they will give a free of cost donation, my lord.
They have given.
My lord, they have given, my lord. That's all.
Lordship, kindly see the first order that the already the compensation part, no notice has been issued, except the environmental clearance issue.
What is the requirement? Where is the requirement?
It should be either the donation, if it is donated by the villagers,
Apart from
who
that,
you are,
apart from
who you are.
I'm a lordship, activist lordship.
If you are an activist, if the landowners in the villages have donated, they want a road.
If I were a lordship landowner, I should have filed in the form of writ petition. This is a PL.
You file a writ petition, so we'll close this.
That is why there is a violation of environmental law as well, lordship.
Hmm?
That is there. Kindly see the lordship.
See,
First,
it's a land of the villagers, right? They have donated the land.
yes.
Is it?
Yes, my lord. They want
Then-
road, my lord.
Then
That is already that part has been already, this honorable court has refused that part, lordship. Kindly see the page number, this order dated.
think
37
over it. Next time we'll dismiss. Heard, Mr. As prayed for by Mr.
Yes.
T. Tapak, learned counsel for the
Solemn lordship.
petitioner.
We will see.
No, it should be before Solung. So that after Solung, you should not have bad omen. Is not it?
Because already there is.
Let all these things go away before Solung. After Solung, we have restart afresh. Afresh for 3 weeks' time to file affidavit in reply
Yes.
to the affidavit of opposition filed by respondent number 3 and 4. Mr. R.H. Chanabam, Learned Additional Administrator General for the State, and Mr. G. Tarak, Learned Standing RWD, are present.
My lord, next time, name of Dugia Soki may be reflected in the cost list.
Why?
He is also now standing counsel, and I have already handed over the file of this case to Dugia Soki.
Standing counsel is there. You manage this. Why unnecessary trouble the paper and ink?
I have already given, they have appointed, government have appointed.
It's all right. You are also there.
Yes, next time he will appear.
It's all right.
Brief is with
That
him.
is your arrangement. Whoever appears to.
Publish.
Item number 12.
Again,
Lordship, I am seeking adjournment of this matter for filing counter affidavit.
Heard, Mr.
Techi.
Techi, learned counsel by the petitioner. As prayed for by Mr. Arkoy, learned counsel,
On behalf of Itago.
appearing on behalf of Mr. T. Tagum, learned standing counsel,
For health.
Health and Family Welfare Department, as well as MS T. Wang, learned state counsel. Further 3 weeks' time is granted to file affidavit in opposition. List up to 3 weeks.
Item number 13.
In item 13, I have instructions to appear for the contender number 1, Chief Secretary.
They have complained or not?
Today we had set once the DPC was set. Today we are again sitting. Today also we are.
What was the direction? To consider.
Yes, Bharat. Earlier also there was a.
We will close it down. Close down.
This matter kept in pending, you know.
Okay, Ibam, heard Mr. Ibam, learned counsel by the petitioner. Mr. Espread for by Mr. N. Learned counsel appearing on my Alice contemner.
Number one.
Number 1 and Mr.
I'm for 2.
Number 2, pray for 2 weeks' time to file affidavit.
Okay.
There's a lot list after 2 weeks.
Item number 14.
14 is, I think, condition.
This interlocutory application is still service awaited, but this lordship matter.
Service
This,
for not yet
press-
received in respondent number 2.
Can this-
Should we wait for some time or?
Press-
1,392.
Yes, madam.
1,392
Yes.
days.
Maybe condonance, huh?
No. This is what?
Criminal offense against conviction. Sentence.
Conviction under?
It's
Section 364A, 121 and 34, madam.
Then I think when the last, I think we can wait for some time. We can wait for some time.
yes.
It was issued in July only, madam.
It's delay is
July. Already July to 2025, 26.
9 June. You have taken steps.
Yes,
We'll
yes.
wait for some time.
Yes, yes, madam.
Await service report in respect of respondent number 2, Mr. Titapak. Learned Counsel for Appellant and Mr. T at the learned scope for respondent number are present.
Obliged, madam.
Item number 15.
My lord, that is condonation of delay of 6 days.
6 days.
6 days. Respondent number 4, private respondent. Notice issued and served as per postal tracking report.
Okay. Notice served.
Notice served and received as per Indian postal tracking report. Last order. In the view of above, the registry to verify the state of the service and list the matter of 27.
Yes.
AD card might be.
What do you say?
No objection, Lordship. Actually, Lordship, we are for respondent number 3, Lordship. And private respondent is the.
Okay, heard, Mr.
AD Verma on behalf of T Taba.
A.D. Barua.
Yes, my lord, Verma, VERMA, on behalf of T
Learned
Taba.
Counsel for the applicant. Learned Counsel appearing on behalf of Mr. T. Taba, Learned Counsel for the applicant. And also had Mr.
K. Tabang, Lordship.
K. Tabang.
On behalf of
one?
Tijamo.
You are one.
2, my lord.
Which one?
One is steering council, my lord, education.
Huh? Mr. Koyu. You record Mr. Koyu on behalf of T. Tabang for respondent number 1. MST Wangmo for respondent number 2, State Councillor, and Mr. T. Tabang.
K. Tabang, Lordship.
K. Tabang, Learned Counsel respondent. Don't appears for the respondent number 4, desperate service of notice. Next, this is an application under Section 5 of Indian Limitation Act 1964, seeking condonation delay of 6 days in filing the connected writ appeal against the judgment and order.
Order dated 5th May 2026.
Zero 5/05/2026 passed by the learned single judge in WPC 531 of 2025. Upon perusal of the grounds and the explanation by the applicant, where they considered that the applicant, the appellant, were satisfied that the appellant and the applicant had been able to show sufficient ground for not filing the connected appeal within limitation period. Accordingly, we deem it appropriate to condone the delay of the delay of 6 days in filing the connected writ petition. No, accordingly, we condone the delay of 6 days in filing the connected writ appeal is hereby condoned. Higher stands allowed and disposed of.
My lords.
We'll go over that, actually. Correcting the technical.
Please for admission. No. Please for admission. Appeal.
Automatically it will be listed. Or should we pass the order? Should we pass the order in appeal?
List. Here only. List.
You just said, in view of the order passed in ISO and so, list of writ appeal after 2 weeks for admission.
Item number 16.
My lords, this is an application under Section 5 of the Limitations Act. There's a delay of 120 days, my lord, in preferring the appeal.
Notice.
Private respondents are there, my lord. So let a notice go. Yes. P. Yobin.
Mr. P. Yobin, Land Counsel for the applicant. This is an application under Section 5 of Indian Limited Acts. Praying for condemnation delay of 20 days in filing the connected appeal. Issue notice returnable by 3 weeks.
3 weeks, my lord. May I pray for 20?
Arisna Leonard. Additional Advocate General enters appearance and accepts notice on behalf of respondent number 1, 2, and 3. No formal notice need be. So have extra copies, please. So and so. Do you need extra copy? No.
Since
Copy
this
has been
appeal,
served already.
my lord, let me go.
My lord, we'll
No,
serve
no
an
extra copy is required. You have all the copy. You have already received
They
a
have
copy.
served only one copy and this is service copy, my lord.
Okay. Then counsel for the petitioners to take steps for service of notice by speed post as usual process. After
22nd September, my lord. So
22nd.
My lord. Much obliged. Division.
Item number 17.
Can this matter be adjourned, Lord, sir?
Why?
Because I have to prepare this citation also in order. Item number 17, na?
This is ready.
That's point number 2.
Otherwise, this is ready.
Oh, then next week.
Okay.
It is no, Mr. T. Tapa, counsel for the appellant submits that he may be granted a week's time to prepare the matter.
Yes.
Mr.
For respondent number 2.
R2.
Respondent number 2. Who is PP? PP is there.
PP. We have. I have discussed.
Who is
yes,
the PP?
I have taken consent.
Theater and is PP and Mr. So and so are present. Prayer for adjournment is allowed. List the matter after a week.
Yes.
Item number 18.
My learned friend has very tactfully rescued the matter from being dismissed on 2 earlier occasions. Well, I don't know.
My Lordship. Lordship, this is file for strike down of the one act of Wapa Lordship, Arunachal Pradesh unlawful Lordship. Lordship, I have annexed that act of the act under challenge, Lordship. May I see the Lordship? Page number 45 is Lordship, in my FARA 9.
Today?
Lordship, I am ready.
Because this means after today, we don't know when we'll sit again. Can it be completed today?
Lordship,
how many judgments you are relying?
Lordship, I have 12, Lordship.
12 judgments?
Yeah, Lordship. Lordship, in fact, Lordship, that I am challenging the one act. It is like the Keshamanda Bharti case related because it was also challenging the one act. Lordship, that.
Do you know how many pages are there in the Keshavananda Bharti?
Lordship, it is more than 800 pages. 8,000 pages, Lordship, more than.
8,000?
Lordship.
Huh?
800 pages.
Which paragraph you are relying?
Lordship, only this part of this basic structure, where basic structure was decided in Keshavananda Bharti, Lordship. The separation of the organ and then supremacy of the Lordship, this constitution. Lordship, supremacy of the constitution and separation of this organ. This
if you want to school us on Keshavananda Bharti,
Lordship.
We'll have to again rejoin in the school or the college.
No, Lordship. In fact, Lordship, this is a case that it is come up from the landmark judgment, Lordship. Because
so?
Yes, Lordship.
Is it?
Yes, Lordship.
Case one on the birthday.
Lordship, this is landmark judgment, Lordship.
How many judges were there?
Lordship, 13 in fact. 13.
What is the highest quorum for the constitutional bench?
Lordship, it is that till that.
Can it be more than 13?
Lordship, that I don't know, but till that there was.
But you are a lawyer. You are relying on a 13 bench judgment. Majority is
6/5, Lordship.
Huh?
6/5, Lordship. Majority 6/5, Lordship.
6/5.
Yes.
Then it is 11. It's not 13.
Lordship.
Huh?
But Lordship, that
if you say 6/5, it is 13 or 11 only, not 13.
Lordship, 7/6, Lordship. Minerva will, there may be some.
That apart, we're just asking whether it can be completed or not.
Lordship, today, my part, yes, my part will be.
No.
Today.
What do you say?
If you enters into the merit, it is going to take a lot of time.
Because it's not that we'll just on the surfaces, on the top, we'll just go and decide the matter. You are challenging an act.
Yes, in fact, Lordship.
Of the enacted by the state legislature. So asking if you can complete today.
Lordship, I will complete today, Lordship.
Not you. Entire hearing can be completed. Or some other day. It should have been listed the Tuesday or last week.
Lordship.
In that case, my lord, your lordship may fix it on 22nd itself. That is a Tuesday. If necessary,
22nd.
22nd of September.
You fix it on 20. If it takes time, it has to be taken time. So you will have to fix it appropriate date.
Lordship, the Lordship main problem is we may consult with the registrar for the listing of the case also. This matter, Lordship.
No, we can.
Number of the case
on Tuesdays, isn't it?
Of course. Tuesday, Lordship.
22nd. October.
Lordship, that Tuesday I cannot find. October next month, Lordship. This may be
next month.
Yes.
Although
27
matters listed for the hearing today.
Important matters fixed.
Since the
vacation.
No, due to paucity of time. Due to paucity of time, we'll say matter could not be taken up. As agreed to by Mr. G. Kato, learned counsel for the petitioner, and Mr. I. Chaudhry, learned advocate general for the state. Let this matter be listed on
13th.
Lordship, maybe on 12, Lordship.
12 is
a Monday.
Make
my learned friend
13.
is praying for October.
13 October.
13th October.
13 October. Maybe lucky for you.
Item number 19.
This we cannot avoid.
Mm-hmm.
Part hard.
Right.
Why this matter was adjourned, on what understanding?
Your Lordship was seeking some instructions from the other side.
That last occasion, my lord, this honorable court was pleased to my lord, the ascertain, my lord, regarding whether there is a decision of the government of India to change the policy. That was the instruction to be my lord, obtained from the ministry, my lord. And accordingly, my lord, that the instruction has come. This is the my lord,
You
instruction.
share with her also? Only
Yes.
2 copies?
Yes, ma'am. I'm
share with her.
Decisions to my lord, change the my lord, the nomenclature and the mandate on the my lord. And how that my lord affects in the recruitment policy, malad, even manpower, everything, malad, the even cost of the malad, the other things that has to be taken care of, madam. Because of that reason, malad, there was a decision to change the nomenclature as well as the mandate, malad. And the recruitment process is the part of the malad, the after this, malad, there was several communications, malad, the even cost and the staff, manpower, everything.
So selection, whatever the selection, it's almost the same thing. Change of nominal status.
Yes, Lordship. Lordship may see the last page. There is nothing there.
Something like nothing.
This is only malad, the resolution and the decision of the government, malad, is the instruction partners.
One in the same thing. Basically, essentially a change of nominal.
Yes.
That's all same thing.
That
Which
is
you have
what
taken. There's nothing nothing striking or something. So we'll decide. That's all. What about that thing? The press selection process.
Selection process, malad, that is under process, malad. Still, malad.
Started in 2022.
Yes, malad. Because of that reason, malad, the ministry is being
How
controlled.
intelligent you are.
Malad, within as per
That the Union of India.
Malad, as per the instruction, malad, within this within 1 or 2 months, malad, everything will be finished, malad.
So the fact remains that only one post.
Yes.
That is also part of the malad, the change of the nomenclature is because
So
the
you
post
don't
has
want to fill up two
malad.
posts.
Because of that
Requirement
reason,
is only
the
one.
post has been reduced also, malad.
Okay. Pass the order.
My Lord.
We cannot afford to hear again and.
My Lord, I also
and-
cannot,
and-
don't have the energy to argue anymore. In any case, what he has stated, it will be over 1-2 months. That submission has been given since 3-4 months.
That's why I said how intelligent the Union of India is. Okay, and Mr. Endangan Learned Council for the
Mrs.
MS Endangan Learned Council for the appellant, and also had Mr. M. Kato Learned DAJ for the for the respondents. Should we keep it CAB or we'll pass the order today? We'll just keep it CAB because you never know. I mean, we don't know whether we'll be able to. We'll make it CAB. CAB, yeah. Hearing conclusion, judgment reserved.
Deep level.
Your Lordship,
Yes.
I would like to mention item number 13. All the respondents have filed their affidavit. So the method to be listed after 3 weeks in the admission column. Meantime, we'll file for rejoinder if required.
On the prayer of MS?
Niche Elizabeth, on behalf of Mr. Titi Tara, a senior advocate.
Mr.
Titi
MS?
Tara, Elizabeth.
MS Elizabeth.
Yes.
Learned counsel appearing on behalf of Mr. Titi Tara, learned senior counsel for the petitioner. Let this matter be listed after 3 weeks. In the meantime, an affidavit in opposition, affidavit in reply
13.
may be filed.
Item number 13.
Please, sir.
Hello, I'm one of the respondents in this case.
Mr. Who else are appearing?
My lord.
Tungan, counsel for the petitioner. Learned counsel for respondent number?
Hello. Respondent number 4.
Private respondent is present. Huh?
Hello, sorry for interruption, my lord. I would like to point out something.
3 weeks.
My lord.
Let them file affidavit.
My lord, in this case, there's an interim order.
Rejoinder.
Huh?
There's an interim order.
Interim order.
There's no interim.
There's an interim order, my lord. Because of that interim order, my future consideration of the respondent for future promotion has been set to hold.
So?
No, Lordship, there is no interim order, Lordship. No
there's-
interim order.
There's an observation that
Yes.
any promotion effected in respect of respondent number 4 shall be subject to the outcome of this.
So, there's
Yes,
no
sir.
bar.
No, since
Yes, after 3 weeks. We'll take it after 3 weeks.
let there be a fixed date.
Yes. Yes, sir.
Much wait.
May I please, my lord?
My lords.
I beg to mention item number 12. My lord, I'm appearing for defend respondent number 6, my lord. Item number 12. My lord, today we are supposed to file an affidavit in opposition.
Mr.
K. Kirkom.
Huh?
K. Kirkom appearing on behalf of Omodi.
K.
Kirkom. K. Kirkom.
Kikong Land Council appearing on me as the Omodi Land Council for respond number 6.
My lord, I may be allowed 1 week time to file.
Respond number 6.
Yes, my lord.
Press for it is granted a week's time to file affidavit in opposition. Yes. List after a week. Your
much obliged.
MS? You're appearing.
Yes, I'm for respondent number 1 to 5.
Why Karga?
Why Karga?
Appearing for respond number 1 to 5.
Yes, Your Honor.
Is present.
What week?
Yes.
Item number 1.
My lords, I apologize for appearing through VC, my lords. I could not come physically down there. My lords, in this matter, we have challenged the show cause notice issued by the learned adjudicating authority, which is the quorum is without jurisdiction, my lords. My lords, the learned single member has issued this show cause notice. And my lords, the final hearing is kept at 2nd of September. My lords, we have raised our objection before the adjudicating authority, but the final hearing has been kept, my lords. My lords,
Where is the show cause?
My lords, Annexure 2, my lords, can come to page number 35. My lords, starts from page number 35. That is the intimation of show cause, my lords. My lords can come to page number 42. My lords, this is a show cause notice that has been issued to us, where we have given time to file our replies by 24th
42.
My lords, 42.
So cause.
My lords. My lords can come to directly to page number 44. My lords can see at the bottom there. The said show cause notice has been issued by learned Pradeep Kumar Upadhyay, chairperson acting, my lords. My lords, the acting chairperson is a member finance. My lords, what I want to submit in this case, my lords, as per requirement, that is the quorum adjudicating authority, as per section 6 of PMLA. My lords, I have annexed the act also at page number 193. My lords can come at section 6(2). An adjudicating authority shall consist of a chairperson and 2 other members. provide that one member each shall be a person having experience in the field of law, administration, finance, or accountancy. My lords, acting chairperson is a member finance, is a single member over there. My lords, recently a judicial member has been appointed on 11th of August. My lords, there is a coordinate bench order also, my lords. My colleague has a compilation of a judgment over there that he can furnish. My lords, the similar writs and other petitions are being pending before 8 high courts, and the Supreme Court also is a preview of this matter, which is being pending over there, whether a single member can issue show cause notice, also not being a member judicial.
You are supposed to file your reply reasoned
My lords,
by
we have
14.
My
You
lords, we
done
have
that.
done that. We have raised our objection also over there, but the
Okay,
matter
that
is
will
fixed
be
for.
considered.
My lords, that is not being considered. My lords, the final hearing comes and the order is being passed. My lords, the reason is that, my lords, the matter is that the financial member has issued show cause notice. My lords, we have raised our objection over there. There's nothing on record which they have said that we will consider that or we will put it for the objection of this, my lords. My reply is already there. My lords, I want to hand over one compilation to my lords. Compilation of
So we'll
judgment.
issue notice. We'll issue notice. That's all.
It will become infectious, my lords. My lords can have my compilation. Coordinate bench has taken a view, my lords, where has stayed the proceedings on the basis of the show cause. So my learned colleague can hand over the compilation of the judgment. My lords, if the final hearing takes place, my lord, the matter get reserved. I have to argue before the learned technical member over there. Even the judicial member is not there. No application of mine while issuing the show cause notice. It is without quorum, my lords. The Act says that there should be a chairperson and 2 other members, my lords. A single member who has issued the show cause notice here.
Heard Mr.
Rishabh
Dubey.
Dubey.
Learned counsel for Rishabh Dubey, learned counsel for the petitioner. The petitioner challenges the show cause notice issued by
Learned adjudicating New Delhi.
chairperson, within bracket acting adjudicating authority under PML dated when it was issued?
June.
When?
25th June 2026.
25/6.
Yes, my lords. June.
25/6/2026 under section 8 within bracket 1 of the Prevention of Money Laundering Act 2002. In original complaint arising out of ECIR number ECR/ITS Z/02/2025 and its proceedings held pursuant thereto on the ground of lack of jurisdiction and vitiated by the vice of quorum non judice list of it is the case of the petitioner that under the provisions, the adjudicating authority
My lord.
request to be consist of 3 members.
2 members and a chairperson.
The 2 members and the chairperson. Mr. Harbour, the notice and the proceedings has been initiated and issued by a sole chairperson, chairperson of acting. Therefore, the initiation of the proceedings and the so-called notice is without jurisdiction. Please issue notice returnable by 3 weeks.
My lords, the show cause, my lords, my final hearing will take place, my lords. The coordinate bench has stayed the proceeding in another matter, my lords, in the same issue. My lords, my colleague can hand over the judgment.
As Mr. You are appearing for all.
Yes.
Learned Counsel, Learned M. Kato, Learned DSGI. For the respondents.
Page number 88.
Enters appearance on behalf of respondent number. All the respondents, no formal notice need be, however, extra copies be furnished to the DSGI.
My lords,
Where it is?
My lords, page number 88.
88.
My lords. The same issue has been challenged, my lords.
88
of the compilation. Global Intrad.
Just
Next, having considered that the similar matters having considered in the similar matters an entry order has been granted. Staying the proceedings, staying the so-called notice. And presently under the CCN SEISN of the Honorable Supreme Court, till the returnable date, the so-called notice dated so and so shall remain suspended. In view of this only.
Page number 183, Malad. Hearing is proceeding is scheduled to be held, Malad.
We'll see. Similar matters are there.
Obliged, my lord. Much obliged.
Item number 2.
Malad, in item number 2, Malad, the Union of India is not a party, Malad. So therefore, Malad, our evidence may not be required, Malad. As UGC only, Malad. And in respect of UGC, Malad.
You are not appearing?
Yes, Malad.
You are not appearing for UGC?
Yes, madam.
Okay.
University Grant Commission respondent number 6 only, madam.
Yes.
So, my lord, the petitioner is a candidate for the post of Vice Chancellor, Arunachal Pradesh University, Pasighat. And in this read petition, my lord, challenges the constitution of search committee, selection committee constituted by the MP notification dated 27/2/2026. My lord will have it annexed to annexure 4, sir. Then, my lord,
page.
My lord, just I'll assist my lord through the pages. I make this one more statement. Now, my lord, the respondent number 2, the commissioner, education, was included as a member of the committee in violation of the statutory bar in the proviso to section 10, subsection 1 of the Arunachal Pradesh University Act 2012. And
sir, so was the first the impugn.
No, I'm coming, my lord. Yes. Now, my lord, will kindly come to the impugn order at page 42, my lord. Impugn search committee, page 42. My lord.
So was way back in on 27 February 2026.
Yes, my lord. Here, my lord, the commissioner, serial number 4, Sri Amjad Tak, Commissioner Education, Government of Arunachal member. Here, my lord, under the act, he is not permissible, my lord. Now, my lord will have this advertisement. Yes, 2000 University Act, my lord, and the UGC guideline 7.30, my lord, 2018. My lord will have this. The annexure 1, my lord, page 21 is the advertisement for the post of Chancellor, my lord. August 8, 2025. My lord will find a fault here itself. As per the guidelines, my lord, first they have to consider the search committee, then only on the instruction of the search committee, they are bound to issue the advertisement. There is also a fault. Thereafter, they have, after the advertisement only, they have constituted this impugn committee, my lord. Then, my lord will see annexure 3, my lord. Page 40 to 41, my lord. I also applied being eligible, my lord.
It's okay. What is the violation?
Violation, my lord, also straight, my lord. 74, just I saw. Annexure 9, no? I'll do. My lord will have this at annexure, the guidelines. Relevant is page 74, my lord, the extract of the UGC guideline. The mandatory requirement under 2018 is that election of Pro Vice Chancellor and Vice Chancellor of universities, my lord.
Seven point
7.3, my lord.
Visitor sense. What is it? Page 74?
Correct, 74. The relevant guy, para. Yeah, I mean, it's a mandatory is not at page 75. One member of the search cum selection committee shall be nominated by chairman, University Grant Commission for selection of the vice chancellor of the state, private and deemed to be universities, my lord. Now, in his place, my lord, now the secretary, the commissioner education, he has been replaced.
Where it is?
My lord, 75. Page,
Page 75.
page 75, my lord, the first para, if my lord will see that last 3 lines from the bottom, my lord, one member.
One member of the church cum selection shall be nominated chairman, university grants for selection of vice chancellor, state, private, and deemed to be university.
Correct.
Then
What had happened was there was a communication to Professor Pravir. All this obtained through the RTI, my lord. Because when the petitioner was invited for the selection interactions, he discovered that Commissioner Education was there. And he made an objection that no, this is the root of the problem of the constitution of the search commission itself, committee itself, in violation of the UGC norms. And he has made a categorical statement that my objection may be minuted, my lord. So that still they have not come, my lord.
one member of the church committee shall be nominated by chairman, university grants committee.
Yes, my lord.
For selection of vice chancellor.
And here, my lord, what had happened?
Prabir Kumar Ghosh has been nominated. It's a UGC's nominee.
But there was a communication from the Professor Pravir Ghosh that due to visit of the Prime Minister, I cannot come, and then requested for the deferment on 15 July. And instead of that, they have gone ahead. So meaning thereby, the statutory provisions of 7.3 of the UGC regulations, which mandates that the nominee of the chairman of
You are challenging the constitution. It
Yes.
has been constituted. If the member doesn't participate, what can we do?
No, my lord. No, the question is, Secretary Education cannot be because he is a office bearer of the university under the Act. Law.
Where?
I'll show you.
Come to that.
Yes.
This nominee so far as UGC norms, the guidelines is concerned, as per the page 42 constitution.
Yes, ma'am.
There's a nominee of the university.
Correct.
Serial number 3, Mr. Ghosh.
Yes.
He's a nominee.
But there was a request.
We don't know.
No. There is a letter. There is an annexure. There is an annexure, my lord. There is an annexure where we have the Bishavarthi University.
No, you are saying that one member has to be nominated, a nominee of the UGC.
Yes.
That has been done.
That has been done.
In the
But primarily, my lord, primarily, the Supreme Court in the latest judgment also says that under whether it is a private university or the state university enacted under the legislation of the state by the state legislature under the list 2 in the concurrent list, it must follow the UGC norms.
Wow.
So that is one. The second thing is that the Commissioner Education in the Arunachal Pradesh University Act law is executive, is the office bearer of the university itself. So he cannot be the search. He cannot be. Just I am showing it. Annexure 8, Lord. Page 70, page 52 onwards, Lord. Okay. निकालो तो.
Mr. Tara, using the technology is creating more problem than solution or inconvenient.
No, Milord, just
convenient than inconvenient.
we will have
Sorry, inconvenient then convenient.
We will have to live with the technology, Milord. My lord, kindly come to section 10. How the Vice Chancellor.
University Act.
Yes. Page 56, my lord.
The Vice Chancellor shall be appointed by the Chancellor from amongst a panel of not less than 3 members who shall be recommended by committee in indicate any order of which the committee shall consider the following: nominee of the Chancellor, nominee of the Executive Council, nominee of the State Government, and nominee of Chairperson of the University Grants Commission, and 3 members shall form a quorum of the meaning of the state.
Correct.
4 members, right?
5.
4 only.
Yes,
4 members.
It's 4
A
members.
nominee of
Correct,
the
correct, correct.
Chancellor who shall act as the convener of the
Yes.
committee. So, state's nominee is there, Chancellor's nominee is there,
Correct.
and the state nominee of the Executive Council.
Correct, my lord.
This serial number 4, nominee of the Executive Council.
Correct.
Then nominee of the State Government, serial number 1. Then nominee of the UGC.
Correct.
And 3 members shall form a quorum of the meeting of the committee, provided none of the members of the committee shall be an employee of the university or member of any authority of the university connected with any approved institution or college or institution recognized or associated with the university. Provided further that if the Chancellor does not approve any of the person in the panel, he may call for a fresh panel from the. Yes.
Now, my lord, we'll see this.
What's wrong?
That is how the Vice Chancellors are to be appointed, and because no one should be the official member, executive office bearers of the university, my lord. My lord will have this page 58, my lord. 16 and 17. 16, section 16, my lord will have now.
Provided none of the members of the committee shall be an employee of the university or member of any authority of the university connected with any approved institution or college institution recognized by or associated with the university. Provided further, if the Chancellor does not approve any of the, yes.
Now, with
the Executive Council nominee is what?
Executive Council nominee, my lord, will find at page 58, my lord. Section 16 we have to read, my lord. First, page 58, my lord. The following shall be the authority of the university. Because the Commissioner Education or the Secretary is part of the authority of the university, in the following authority, my lord. The court, the Executive Council, Academic Council, Planning Board, Finance Committee, faculties, such other authorities as may be declared by the statutes to be authorities of the university. Now, 17(1), my lord. Now, my lord will kindly have this section 17, 1, 6.
He is Commissioner on Education, not Secretary.
My lord, there is no official designation called Commissioner. It's only Secretary, either Additional Secretary or the Additional Chief Secretary. But because whenever any IS officer who reaches the pay band 14, then on the basis of seniority, they are designated there. Nothing else, my lord. There is no such official title assigned. Now, my lord, will kindly have this page.
Commissioner is not a member of this. It's a secretary.
But he is a Commissioner Secretary, my lord, will see this.
What does it say?
Yes.
Commissioner on Education, Government of Arunachal Pradesh, not secretary. Secretary is different.
Yes, my lord.
Had he been a commissioner or secretary, one could have understood.
But then kindly see this, but still he is the authority, part of this, my lord.
Where?
Here, just kindly come to section 17.
17.6.
17.6, yes, Secretary Education,
what I'm
Government of
saying.
Arunachal Pradesh.
The nominee of the Executive Council is the Commissioner
Yes,
of Education,
yes.
not the Secretary.
And similarly, in section 18.1, my lord, the Secretary Education.
Secretary, Education, Government owner. All Secretary.
Yes.
Not the Commissioner.
Fine, my lord, that is also there, my lord. So therefore, he is an ex officio statutory of both the Executive Council and the academic body, my lord. So therefore, he acted as a representative of the state government there. Now, my lord,
He is the nominee of the Executive Council.
no, he is not the nominee.
Gee, page 42, Executive Council's nominee. That notification, Constitution.
But the university has never nominated him, my lord.
No, Executive Council.
Yeah, he's a nominated, yes.
Yes.
Now, my lord will see this.
Other than this, admittedly, he's a commissioner.
Correct.
Maybe by virtue of commissioner, he may be. But it doesn't indicate the commissioner or secretary. It's only the secretary. Other than this, you show us that this commissioner education is the member of the court or the council.
Go the council, my lord.
Show us any document.
That's why, my lord, I kindly have this clarification from the state itself.
So we should
but have one more point, my lord. I have this. Allow me, my lord. Only give me 3-4 minutes. I'll finish it off, my lord. I have 2 limbs of submissions, my lord. So now, here it says, my lord, kindly see this. What I am contending is, my lord, the Secretary / Commissioner Education, to my understanding. Now, here is an ex officio statutory member of both, my lord, Executive Council and so court and whatever it is, my lord. Now, respondent number 2 is therefore in law a member of any authority of the university is squarely within the disqualifying proviso, my lord. That is my contention, first contention, my lord. Now, kindly see, my lord, in the section 10 itself, my lord, I have seen, it itself contemplates a nominee of the Executive Council, that is a person chosen by that body, not Executive Council's own ex officio member, being sitting in a judgment on the selection for the very university of which he is a part, to read the proviso otherwise would permit self-review by the very authority whose head is being selected, defeating the manifest legislative object of insulating.
What do you say?
My lord. Now, my lord.
Just wait. That's all. Enough.
No, 7.3, my lord. UGC regulation I am coming.
I have seen.
And then I am placing the judgment, my lord.
See, there are two, your submission, if I have correctly understood, the nominee of the UGC who has not participated, he who has expressed his difficulty to participate, although nominated, was not present, but then they have proceeded. Number 2, the commissioner being the member of the, under the act of the university, as in the court or some executive council, he could not have been a nominee of the executive council. That's the thing.
That is contrary to the UGC regulation, my lord.
Yes.
If it is against the UGC regulation, the constitution of the committee itself is void ab initio.
That's what I'm saying.
Yes.
That's what I'm saying. In this case, it is not something that's it's violation is violation. But then how it is violated, that you have to show. So now, that's why I'm saying this nominee of the Executive Council appears to be a Commissioner of Education. There is no dispute that there is a nominee of the UGC. There is no dispute to the Chancellor's nominee. There is no dispute to the state's nominee.
Correct.
The dispute is essentially the Executive Council's nominee. According to you, he being a secretary, a commissioner, come secretary, is a member, could not have been a member of the
part of it.
Search Committee.
Part of it.
But this court primacy of the view that since the commissioner is the nominee in the Search Committee and not the secretary, he is not a member of the university. right? And for that, we'll ask them to clarify whether the commissioner, secretary, same thing, whether the commissioner is the member under the act, as in the court or in the council, executive council. If the commissioner, by virtue of a commissioner, even if it is written as secretary,
Correct, my lord.
secretary is the member,
Yes.
not the commissioner. If they say that in view of there's no secretary, in view of being a commissioner, he's the member, then you have a point. You are right. But by reading this, on the records of this, on the face of this, it's not a secretary, it's a commissioner education. Therefore, we'll ask them to clarify. Will issue notice?
Tomorrow, my lord. Is a small smooth.
Tomorrow, my lord, it will not be possible, my lord.
Why not possible? In fact,
otherwise also, my lord.
See, very simple.
Yes, my lord. Yes, my lord.
Although he is designated as a commissioner, Act requires that the secretary is the member.
Yes, my lord.
So if you are the member or connected with the university, you cannot be a nominee. You cannot be a member of the church committee, right?
True, madam.
Now, if there is a member as a secretary education in the church committee, you have, he can be a member.
No, my lord, since the education department, my lord, at the time of this issuance of this notice, my lord, notification.
So you tell us.
The department was having both commissioner and secretary, my lord. Both, they are independent to each other, my lord.
Yes.
In personality, my lord, in person. So therefore, my lord, this act clearly provides that
is that
if the secretary.
That is exactly we want you to clarify.
Yes, my lord.
And whether the secretary education is the member of under the act, or since there may not be a secretary now, by virtue of commissioner education, he is the member.
No, my lord, in one of the notification, executive commission notification, he is the one commissioner education who participated in the council, my lord.
Where it is?
My lord, I have these documents in my.
No, you will have to bring on record.
I'll file additional affidavit, my lord.
And also, my lord.
Very simple. Your instruction is very simple.
Yes, my lord. As per section 10, my lord, which my learned senior colleagues is relying, my lord. Section D permits, my lord. The quorum is 3 only, my lord. Though, my lord, as the nominee of the UGC,
remain absent.
May remain absent. Yes, it has the requisite quorum.
It goes.
Yes.
UGC goes.
Yes, my lord.
Only this executive council's nominee.
To that extent,
if he is a member, he cannot be.
Yes.
Irrespective of whether secretary or commissioner. But the Act requires that it is the secretary, not the commissioner.
Yes.
So you take that, bring that, why to make it? Yes, heard Mr. Titi Dara, senior counsel.
Before this, my lord, only one particular.
It's okay, we'll take it. It's a very simple issue. Sir, if the commissioner of education is a member of university, he's out.
Yes.
They cannot proceed.
Tomorrow, my lord.
Right.
Tomorrow, my lord.
Why
and release this
make
matter
it,
tomorrow.
make it more complicated? Yes.
Tomorrow.
The senior counsel assisted by Mr. G. Bam, learned counsel for the petitioner. The petitioner challenges the notification that at 27/02/2026 issued by the Chief Secretary, Government of Arunachal Pradesh, constituting search committee under section 10 within bracket 1 of Arunachal Pradesh University Act 2012 on the ground that the commissioner within bracket education government of Arunachal Pradesh being the member of the authority Under section 17. Section 17. Is it section?
Section.
Yes,
Section
yes.
17
Section
within
17.
brackets. Roman, small Roman 6. Is the member of the Arunachal Pradesh University Act 2012 is a member of the court, public authority of the university. And
my lord,
also
I'm
the
sorry, this notification is here, my lord, where
UGC
he has
nominee,
been the member.
UGC nominee
Amjad Tak, yes, my lord.
has also not attended the
I forgot the name.
proceedings,
Just give it.
which would be in
Yeah,
violation
notification
of
was there.
section 10
We forgot to.
within bracket 1. A proviso to section 10(1) of Arunachal Pradesh University Act
I'm
2012
showing
and UG, what is this
UGC regulation 7.30.
UGC regulation
7.30 2018.
7 point 3.2. Next para. Having considered that the 17.6 and the 18.3 under this University Act, having considered that the executive nominee is the Commissioner of Education from Government of Arunachal Pradesh, whereas the members of the court and the Executive Council of the University under the Act of 2020, 2000, under the Arunachal Pradesh University Act 2012, is the Secretary Education Government of Arunachal Pradesh, Mr. D. Kabduk, Learned Additional Advocate General, is to obtain instruction as to whether the Secretary or the Commissioner, Secretary Education or the Commissioner within bracket Education is the member of the court, public court and the Executive Council of the University under the Act of 2012.
My lord,
List
just
tomorrow.
My lord, kindly permit me to file this as the additional affidavit.
No, who is stopping? You file it.
My lord, have this.
Since you are
Amjad Tak is already there. My lord, kindly see this. He is already there in the Executive Council. This critical documents I missed.
Learned Counsel for the petitioner may file affidavit, additional affidavit to bring on record any documents which shows that the Commissioner of Education is the member of the court of the Executive Council of the University.
Okay, tomorrow.
Tomorrow, list the matter.
Great.
You just clarify.
Yes, sir. Yes.
Is the executive member, council executive member?
Item number 3.
You just write here, challenges the Chancellor Notice Church Committee for appointment or selection of Vice Chancellor of Arunachal University. What is this university?
Arunachal Pradesh University.
Arunachal Pradesh University. Pasiga. Take it from the advertisement. Yes.
Your Lordship, this petition is for directing the responding authority to.
Admitted.
Yes, Your Lordship.
Admitted.
Yes, Your Lordship.
Admitted bill.
Yes, Your Lordship.
Admitted amount.
Yes, Your Lordship.
Yes. Will issue notice.
Yes.
You obtain instruction. Heard Mr.
P. Wangpan, Your Lordship.
T1 Learned Counsel for the petitioner. By filing this writ petition, the petitioner seeks for a direction to the respondent authorities to release the outstanding bill amount of rupees 2 crore 50 lakhs on account of the execution of work of rectification of the R&D project under PMGSUI road from Khasa to Botnu.
Botnu, Your Lordship.
Botnu.
Yes, Your Lordship.
Botnu in the district of
Longding district.
in Longding in the district of Longding, Arunachal Pradesh. Next para. Issue notice returnable by 4 weeks. 3 weeks. Mr. G. Tarak, Learned Counsel for the Learned Standing Counsel, as Mr. G. Tarak, Learned Standing Counsel, RWD, enters appearance on behalf of all the respondents, no formal notice need to have extra copies, which
Must apply, Your Lord. Extra copy.
extra copy.
Yes, Your Lord.
In such case, you just obtain this, if it is admitted, pay.
Item number 4.
May I please, Your Lordship? Well, this matter is related to acquisition of 4 acres of BOP by the ITBP. Now, in this case, my lord, award has been already passed, my lord.
Yes.
So I just take to the summary of award is.
Why award is passed? Why you have not been paid?
My lord, still.
What is your stand? What is your prayer?
My prayer is that the compensation should be paid to the petition for the land which has been acquired for the BOP by the ITBP.
It has already been
acquired.
Award has been made. Already.
Yes, my lord. They have.
Has been already passed.
Yes, my lord.
Then what is the problem?
No, Your Lordship.
They have issued the requisition, and then there was a preliminary notification, survey and hearing, and then.
What is the problem? Why they are not paying?
My lord, I don't know, my lord.
Proceedings is.
My lord, the award has been passed.
Acquisition proceedings have been
completed. Award is passed.
To award.
Yes, my lord.
Then why they are not paying? Why you are not paying?
Award was
What is
passed.
the problem? Just
Award was passed on 26/5. Yes, my lord.
Yes.
Your Lordship, I'm for the Deputy Commissioner, Your Lordship. We have
Why
only passed the summary of the award has been passed, Your Lordship.
Then
Yes, Your Lord.
who has to pay?
ITBP,
my lord.
ITBP, Your Lordship.
Yes. What is your stand?
Is actually in, he has his induct in the other court. He wants to attend it.
Huh?
It may be passed over, Your Lord.
Have you filed the affidavit? They have filed the affidavit.
They have filed affidavit, but then that was stand was different. Earlier their stand was that land comes under the reserve area, but now it is very clear as per the divisional forest that it is the land of the petitioner. So accordingly, the requisition was there, and then the award has been passed.
So what is the stand of ITBP? They filed the affidavit.
They have filed. Earlier, they have
They are
filed the
the one
affidavit.
who has to give the money?
Yes, ITBP has to.
They filed the affidavit. What is their stand?
But latest, after the award, they have not filed any affidavit, madam.
Obviously, they'll take time again. So what's the use of,
Otherwise, it can be disposed of. Otherwise, award has not already passed. So accordingly, the respondent can take.
Then after some time, we'll see.
Yes, madam.
Okay.
You inform him. Huh?
Yes.
Item number 5 and 6.
Yes.
Yes, I'm going to respond in the private respondent, item number 6.
Your Honor, I'm here for the respondent number 8. I'm appearing on behalf of my learned senior counsel, T. Garam.
Yes, what is the additional affidavit filed by the petitioner? Kept on record. What is this additional affidavit? What is the status?
The petition number 390, which says that it is not maintainable.
Not appears for the petitioners on call. Separate orders. Same issue.
No, one they have challenged the police decision, or here the employees being absorbed in the RD department.
Then at
Here
6,
also the writ petition is, we are saying writ petition is not maintainable.
then item 6.
Item 6, this is only for framing of recruitment. If we say
Yes, it non appears for the petitioner on call. Who else? Mr. B. P. Learned Counsel for the
number 2, 3,
Standing Counsel for RD for state respondents and Mr.
Your Honor, T. Appa.
T. Appa for respondent number
8.
8 in both the cases. In both the cases?
No, item number 6.
In WPC 420 of 2022 and Mr. M. Tasso Learned Counsel for respondent number 6.
9, 10, 11,
11, 9, 10, and 11.
11, 13, and 15.
In all the cases?
No, item number 6. WPC
In WPC 39020. Having considered the issue raised in the petition and considering that the matter is pending since 2022 and 2024. It appears that the petitioners are no longer interested to pursue district petitions. Accordingly, petitions dismissed for non-prosecution.
Item number 7.
May I please you, my lord?
Yes.
What is this? This is regarding the dismissal from the service on ground of unauthorized absence, my lord.
Affidavits, pleadings.
They have submitted, and in their affidavit, they have admitted one thing very clearly.
Mr.
R. Deuri.
R. Deuri, learned counsel for the petitioner. There was a departmental proceedings.
Yes, it's Assam Rifle.
As well as Mr.
Kamin Dangan.
K. Dangan, learned counsel for the appearing on behalf of Mr. M. Kato, learned DAJ for respondents
1 to 4.
Admit list for hearing. When?
My lord, on 24th of next month.
On 24/09/2026.
And in fact, we have submitted
the learned counsel for the respondents to produce their reports.
Deeply obliged.
Item number 8.
Lordship,
yes, instruction have you filed?
Lordship, actually, in this matter, at that point of time, Lordship, that is, there are also someone else who have already taken voluntary retirement. And then these incumbents, they don't know what to say anymore, Lordship. They are clueless. I mean.
Very strange.
Lordship.
Lordship, this is.
You don't know. He's DLRSO. He's an officer.
Lordship.
Grade A officer.
Now.
Grade A officer.
Lordship.
And he doesn't know anything what to do.
Lordship, those.
By granting sometime, otherwise you'll pass an adverse order against him. How can he say so?
No, Lordship.
How can he say that he don't know what to do?
No, Lordship, especially to clarify those things, Lord.
Yes, he has to.
Even in
From the records, what had happened, he has to find out and must be under record.
Lordship.
Simply we are granting you sometimes we're not commenting anything
Lordship.
in writing. Do something. Cannot be like that. Just inform the concerned LDLI, sir. It's not the way. They have to do it. Isn't it?
Yes, Lordship, I have
Am I wrong?
Lordship.
Am I wrong?
No, Lordship.
Heard Mr. G. Kato, learned counsel for the petitioner. Will not comment anything. As on today, will not say anything.
Lordship.
As prayed for by MSD at the London Additional Senior Member. Further, 2 weeks time, 3 weeks time is granted to obtain instruction
Last
as allowed by
So
this
that
court. As a last chance.
Lordship.
Ask them to work out.
Okay.
This way, that way, whatever may be.
Yes.
We'll decide thereafter.
Item number 9.
Yes.
Lordship, here the land management has not yet filed their counter affidavit. In fact, DC and GSI they have filed.
You have also not filed reply.
I have filed.
Okay. 1 and 2.
Yes, Your Lordship.
You want some them?
Your Lordship, I think the affidavit of Deputy Commissioner will suffice, Your Lordship.
Who is 1 and 2? This matter is about what?
Challenging the eviction.
Eviction order, Your Lordship.
Deputy Commissioner is enough.
No, Lordship, what is the Deputy Commissioner, he arbitrarily issued allotment to the GSI, land measuring 82,000. However, now we have obtained the RTA record. Government.
File whatever is it.
Yes, Your Lordship.
Heard Mr. Arko learned counsel for the petitioner. Is prayed for by Mr. Learned State Counsel. Further 3 weeks time is granted to file affidavit on behalf of state respondents.
1 and 2, Your Lordship.
Affidavit in respect of respondent number 1 and 2 have already been filed.
No, sorry. 3 and 4 we have filed.
3 and 4.
We have filed.
3 and 4.
1 and 2.
1 and 2, Your Lordship.
Just after 3 weeks.
Obligations.
Interim.
Interim order passed, LS will continue.
Item number 10 and
Yes, sir.
10 and 11.
They have filed their evidence, my lord. 27
Sir.
witnesses they have filed. We can proceed.
Not
fix the date and
27,
proceed the
sir.
process.
Come on, again. That's the whole difficulty. No, IAs are mine, witnesses are mine. He doesn't let me speak. He starts speaking. Not 27.
My lord
28.
asked me something. I was just responding
No,
to
sir,
that.
please. I'm addressing my lord. Kindly.
Sorry.
Sir,
Please
bear
go
with
ahead.
me.
Please go ahead. Sorry.
Sir, bear with me.
Sorry.
No, Mr.
It is not
Mr. Theory,
27.
I asked him.
Oh, very well. Then
That's
I'm
why.
sorry. I'm sorry. No, my lord.
It's
out
not.
of the total.
It's not on his own volition.
I'm extremely sorry. I
I've asked
apologize to my.
Because
I apologize to my learned friend. I apologize.
Because you are not visible at that point of time.
Oh, very well. I'm sorry.
Because they have
Extremely
not.
sorry.
They have not lifted the screen.
I apologize to my learned friend. Now, my lord,
We talk
out
to
of
the-
the total.
We talk to
I should
people who
always.
is visible. We cannot talk to the person who is invisible.
I have offered my apologies to my learned friend. Now, my lord, out of the total,
Yes.
47 listed witnesses,
Hmm.
we have total 47 listed witnesses. Out of the 47 listed witnesses, we have filed evidence on affidavit of 28 witnesses total. Now, my lord, so far as 28, 28.
28, yes.
Yes, we have dropped 7 witnesses.
Okay.
Yes, that's number 2.
Uh,
Now, my lord, so far as 12 witnesses are concerned, that is witnesses from serial number 40 to 47 of the list of witnesses, and witnesses from serial number 5 to 8 of the list of witnesses. Total for 12 witnesses. They are all government officials. So, my lord, naturally, we can't file their evidence on affidavit. So, my lord, IA 178 has been filed for issuing summons to these witnesses, these listed
Okay.
witnesses. So
Yes.
that is it. In paragraph 2, my lord, I have given the details of 8 witnesses from serial number 40
So
to 47.
We'll take it up 178 first.
Yes, my lord. Yes.
Or 93. What is 93?
No, my lord, not nothing. Lordship may kindly take 178 first.
Okay.
178. Now
179. 178.
178. So in paragraph 2, my lord will find there are details of 8 witnesses from serial number 40 to 47. Paragraph 2. Serial number 40 to 47. I have furnished the details, address, everything. Summons have to be issued in their case. Then in paragraph 6, I have given the details of 4 witnesses, that is from serial number 5 to 8 of the list of witnesses. So total 12. So my lord, summons need to be issued in respect of these 12 witnesses so that they appear before the Honorable Court. That is IA 178, nothing more.
Okay.
My lord, I have a suggestion, my lord. As far as serial number 2, paragraph number 2 is concerned, there are 40 to 46. If your lordship will see, there are 4 polling stations. The allegation is with regard to 4 polling stations. So presiding officer as well as polling officer from each polling station, they are summoning. Instead of both officer coming, my lord, one officer, the presiding officer, he is in charge of the entire polling station. The polling officer reports to him. He is the final authority as far. So only the polling officer may come, my lord. Otherwise, it is a wastage of time because the government officer will come leaving all his duties because because all the documents are on record. We have already produced the documents, my lord. Lordship has directed, they have produced it. So one officer is enough from each polling stations instead of calling all 8.
It's okay.
I'm rendered speechless. My list of witnesses, my witnesses, in accordance with law, I have filed an application.
We'll issue summons to all.
Milord, 87, Milord, there is a,
all.
Milord,
Sir, it's all right.
Milord, section 87.
Then we'll not go into all this now. Sir, we'll proceed.
Milord, it is...
Since they have filed the list of witnesses, we'll go for that.
But
go by
that. The same purpose, there will be no additional purpose.
So there are how many? 12 witnesses?
12 witnesses, my lord.
This serial number
Paragraph 2, para 2 and para 6.
6.
And
yes,
para 6 also, my lord, I have one submission, my lord. Lordship will see, my lord, para 6, serial number 6 and 7. So these 2 witnesses are with respect to the gun license issued to the respondent. So that is not in dispute. Only dispute is...
Since they have already submitted the list of the witnesses, we'll call them.
Very well.
Dispose of. But problem is one. We'll have to give a fix there.
Yes, my lord. Lordship has to fix dates, my lord.
And it's difficult. From next 2 weeks, we don't know. Next week, I'll be in principal seat.
I am told, my lord, from September, my lord, the 14th onwards, Lordship is sitting here and probably...
That's the problem. We don't know.
Lordship may fix a tentative date, my lord, from 21st next month. So it will take some time. So 27 witnesses they have already filed, my lord. So those witnesses we can proceed. In the meantime, summons may be issued to them, the official witnesses. The evidence which is already on record, my lord, those witnesses, because that has to proceed, my lord.
Sir, you just tell us what
could it be, my lord,
once we issued a summons, it should be on given and we fixed it.
My lord, my submission would be, my lord, because my difficulty is on 22nd, my lord, I have prior engagements, I'm hard pressed. 22nd and 24th, both, my lord, I'm hard pressed. If it is on 28th is Monday, so my lord, continuously, then it can continue. My lord will be here and
is fine.
are there.
We don't know, but we'll fix, as on today, we'll fix it on 28th of September.
Serially, it may go on.
And And the witnesses remain present, my lord, the private witnesses.
We'll say that. So we're fixing it on 28.
Yes.
Yes.
And Mr. in IA 178, huh? PKT, learned senior counsel, assisted by Mr. Arantunga, learned counsel for the applicant, public respondent. And also had Mr. R. Biswas, Rituraj Biswas, along with Mr. Who is there?
He's not there. He's some other court.
Yes. DJ Kapil.
DJ Kapil.
For the opposite party election petitioner. Next para. This application is filed for issuance of summons for attendance of witnesses for evidence. Next para. Issue summons to the witnesses. Para, Para 2 and Para 6, right?
Yes.
Yes, my lord.
Para 2 and Para 6. Name of the, you just mentioned the name of the witnesses, among them witnesses are directed to appear on 28, 9/20, 6 for evidence. List evidence, That's
on 28.
Including the private witnesses also.
Can we do it on the same day?
My lord, the private witnesses, my lord, if they come, my lord, their evidence is already on record, my lord. So we will prepare the cross questions. We will start the evidence because at least 5 of them may.
My lord,
Yes,
my lord, let me explain. First of all, my lord, I have to complete my evidence in chief. Unless and until I complete my evidence in chief, there is no question of cross-examination. Cross-examination begins after the completion of my evidence in chief. This is what
that is not. This doesn't apply because these are not his private witnesses. These are government officials, my lord.
It's okay, we'll see.
my evidence in chief is not over, sir.
In any case, we'll not be able to complete on 1 day or 2.
20, So it will.
So we can suppose if we complete on 28, next day or another 2-3 days, we can ask those private witnesses to.
Very well.
Right?
Because cross-examination, my lord, begins
Okay,
only
this
when
is this
evidence in chief is over.
178
It is disposed of.
What is 179?
There's one more.
179, my lord, I am not pressing.
Oh.
I am not pressing. This may be, my lord, closed
So
on the ground of not being pressed.
Not being pressed, IA 1710 stands closed on not being pressed by the applicant, Then 93 is what?
93, I think, my lord, that will be taken up. Okay.
At the final
That will
hearing,
be-
there is already an order
Okay.
Yes.
of 25th of March, May.
93. Okay.
14th of May order. It will
Then
be taken up.
in election petition, you write hard so and so list the matter on 28. 28.
28.
In main petition, we'll pass the order fixing that it on 28. Okay.
Very good.
Item number 14.
I confusion ng takatulay. I confusion ng takatulay. Yes. Except respondent, the remaining respondent have not filed their affidavit. Yes, affidavit.
I have filed, my lord.
You have filed.
Yes, ma'am.
Non appears for the. You are filing.
Yes.
You want some time to file affidavit. You are for?
Number 4 to 9.
Non appears for the petitioner on call. MS T. Wang Council for the Legislative Council for respond number 3.
1 and 3. 1 to 3, ma'am.
1, 2, and 3 submits that an affidavit on behalf of the state respondent has already been filed. Next para, as prayed for by Mr. N. Kuru. Learned Council for respondent number 429, 11 to 17, 19. 19. You just give this. First, 3 weeks time, further 3 weeks time is granted to file affidavit.
Lordship, I am for respondent number 20, Lordship.
You want to file?
Yes, Lordship.
Then in that case, then is name K.
Tabang, Lordship.
Tabang for private respondents.
Private respondent, Lordship.
Private respondents for the 3 weeks time. Up to 3 weeks.
Item number 15.
We need some more time.
No appears for the petitioner on call. However, Mr. Arkoi, Learned Standing Council.
On behalf of people.
And the Learned Council appearing on behalf of Mr. Learned Standing Council, Mr. T. Tagum, for health and family welfare. And MSP Sangeeta Learned Standing Council are present. Award service report list after 4 weeks.
Okay.
Item number 16.
82. 82. We'll resume 82.
Malad, in item number 4, Malad, as per the instruction, Malad, the award has already been filed, Malad. Award has already been passed, Malad. To that extent, Malad, I have gone through the affidavit filed by the ITBP. Malad, there is nothing, Malad, to whisper about the acquisition and the other things, Malad. So therefore, Malad, at this stage, Malad, may I pray that I may be given some time to take instruction in respect of the award passed by the Malad department, Malad.
Yes, heard Mr. Esmo. Item 4.
Item 4.
None counsel for the petitioner.
First week. Second week.
Only to take instruction.
Malad, your lordship may fix the date, Malad. Maybe second week of September.
None counsel for the petitioner. Next pair. Who submits that after acquisition of the land of the petitioner? In this for
Sorry?
For what? Acquisition for what?
For border outpost.
Border outpost.
Of ITBP.
ITBP.
At places some.
The award has already been
passed.
When?
26 May 2025.
26 on 26/05/2005. Please do. However, affidavit filed by the ITBP, respondent ITBP, does not indicate as regards the award list of in view above and as spread for by Mr. M. Kathor Learned DSJ for the respondents. Respondent Union of India.
Malad.
2 weeks time is granted.
Yes.
To obtain its.
Your lordship may fix the date.
After
date.
2 weeks.
After 2 weeks, Malad.
2019.
2 weeks, Malad, then September.
14.
14.
Obliged.
Item number 16.
File the affidavit. Now you are not challenging, I mean, you are not pressing the discipline proceedings.
Yes, madam.
Only in that case, we'll list it for hearing next week to dispose of the matter. Because once, suppose, if you grant interim today, it amounts to granting full relief. Because you are not pressing the discipline proceedings. It's going on now.
It's going on, my lord.
And it's better you cooperate, because if you say so on the merit, you may be exonerated also, is not it?
Well,
Because if you pass an interim order, it's in respect of the extension.
My lord.
Once the extension goes,
My lord.
nothing remains. So better to hear and fix it for, admit and list it for hearing next week. That would be better to dispose of the matter. Or are you pressing the disciplinary proceedings also?
Then in that event, my lord, I will also press the my lord disciplinary proceeding, my lord.
Therefore, we'll list it for hearing next week and you fix it.
My lord, my submission is that, my lord, my lord, the extension order is not based on, my lord, any, my lord, objective, my lord, satisfaction of the, my lord, disciplinary authority.
It's
my lord.
objective or subjective?
Objective, my lord.
It's objective satisfaction.
Yes. Not only subjective, my lord, but it has to be objective satisfaction, my lord, of the assessing authority, my lord.
Yes, what do you say?
I will rely on, my lord, only three judgments, my lord. Two judgments of the Supreme Court and two of our Honorable High Court, my lord.
Lordship, yesterday I already placed 3 points, Lordship. One is, Lordship, is admitted position, Lordship. This the part of the Lordship merited the case. That okay, I'm not touching on that, Lordship. But that has to be kept in like on the background, Lordship. It's admitted that it was back, Lordship. And second, Lordship, is that Lordship. As I've submitted, Lordship, there's no any other place to post him, Lordship. There's only one institution, Lordship. He's a deputy secretary. If he's allowed to, Lordship, serve their Lordship, then definitely, as per the recommendations and extension order, it's already reflected, Lordship. It will prejudice the Lordship, the departmental proceeding, Lordship.
No.
That is the mind behind the Lordship extension. That has been reflected in the order itself, Lordship.
It is the mind behind, my lord, but, my lord.
That cannot be mind.
Yes.
Mine has been reflected, Lordship.
No.
That mine has been reflected in the order, Lordship.
To my submission, my lord, it is not a subject, objective
Basically,
assessment,
I'm
my
of the
lord.
view that we cannot consider at this stage so far as the initiation of different proceedings concerned.
Right.
That has already commenced, which you are participating. In that case,
Of course, my lord.
we may not at all, go into. Therefore, you may raise that disciplinary proceedings also at the time of hearing. We'll fix it next week because he's out of job suspension. And he fixed that next week.
On, my lord. Oh, yes.
We'll admit and list for hearing on a fixed date.
On admission hearing, my lord. On second, my lord.
No, it's better to admit and fix it for hearing on a particular date.
It may not be.
It reaches.
It may not reach, my lord.
We have only 2-3 cases in a day. Hearing matters.
No, for admission hearing, my lord. My lord.
Okay. Heard Mr. Arseke, learned senior counsel, assisted by Mr. Elbam, learned counsel for the petitioner. and also heard Mr. Estafin, learned senior government advocate for the response. As agreed to by learned counsel to the parties list this matter. No, considering that issue in both, which pertains to continuous suspension of the petitioner and the departmental proceedings has already been commenced. Even after commencement of the departmental proceedings. Let this matter be taken up. Let this matter be listed on listed
on second, my lord, September, my lord.
Listed next week. Next week, Mr. It is. It is observed that endeavors shall be made to dispose of the writ petition at the admission stage. List of, as agreed to by parties, list the matter.
My lord, I have a matter My lord, another prayer, my lord. My lord may kindly,
2026.
my lord, direct the my lord, my friend, my lord, to produce the my lord, the records pertaining to my lord, extension of the second my lord, suspension order, my lord.
They have annexed.
My lord,
They have annexed.
my lord, the records pertain to my lord. There will be many documents, my lord. Constitution of the review committee, my lord. Fixing date of the review, my lord. All those things, my lord, may be necessary, my lord. Will be necessary, my lord.
Okay, you produce that. Learned counsel for the
particular order.
Learned counsel for you are senior government advocate, no?
Lordship, I'm appearing.
Learned counsel for the respondents to produce the record in respect of proceedings
dated
proceedings of extension of
second matter suspension proceedings of matter review meeting held on 12/6/2026, my lord.
held on 12/6/2026.
If the document is specified, then Lordship, what exactly document? Because
No,
minus
proceedings include minutes only.
minus only the annex, Lordship.
It's right. You produce that.
My lord, the files relating to the review.
No, what
We'll see a record.
record,
my lord.
Lordship?
Yes, ma'am.
We'll see.
Lordship. Because otherwise minus is already annex,
Minus is
Lordship.
there. Yes.
Lordship. And